Hello, and welcome to Law Talk. My name is John Celebrezzi, and I'm the co-founder of the Celebrezzi-Zangi Community Legal Education Project, as we call it, CZ-CLEP for short. Our organization provides continuing education about the judiciary and legislature to attorneys, judges, government officials, and the general public. As a career educator, I recognize early on how important legal matters are and how they impact our lives. I am the nephew of the late Anthony J. Celebrezzi, who was the popular 5-term mayor of Cleveland and a member of President Kennedy's cabinets. As a tribute to his lifetime commitment to the legal process, we dedicate this show.
John's special guest today is Judge Lynne Callahan. She earned her Juris Doctorate degree from the University of Akron Law School in 1984 and was thereafter admitted to the Ohio Bar. Judge Callahan was appointed to the Akron Municipal Court on May 1st, 1997, elected again in November 97, and re-elected in November of 2003. Judge Callahan was instrumental in the creation of the Akron Municipal Court's Family Violence Court and presided over that court from April 1998 until she began her service on the Common Pleas Court in 2009. During Judge Callahan's tenure, the Family Violence Court received the Ohio Department of Rehabilitation and Corrections Director's Award for Excellence in Community and the Justice and the American Corrections Association National Exemplary Offender Award. Judge Callahan was elected to the Summit County Court of Common Pleas in 2008, re-elected in 2014. She has served on the Common Pleas Court until 2017, when she began serving as a judge of the 9th District Court of Appeals, following her election the previous November. Judge Callahan is a lifelong resident of Summit County. She and her husband, Michael, have 3 children and 4 grandsons. Now let's join John and his special guest, Judge Lynne Callahan.
Judge, welcome to Law Talk.
Thank you for having me. I appreciate it, and I appreciate you doing this.
Well, we're certainly glad you're able to join us today. Through the years, I've had the pleasure of doing the show for almost 10 years now, and I always like to have appellant judges join us. I appreciate you've been a judge at various different levels, as some of your colleagues have. But I do believe, Judge, that my viewers always find this pretty interesting because a lot of people don't quite understand what an appellant judge does. And the purpose of Law Talk is legal education, so you were high on my list. And I'm proud to tell you that earlier this year we had Judge Theodosio on. So, and I think through the years I've had most of your colleagues. So,
I think you have.
So
I think you have.
Kind of fun to have you. Well, if you don't mind, you see I have my trusty clipboard here.
That's fine.
That'll kind of keep me honest here as far as moving us right along. But I mean, I think this is a question I always like to ask to many of my guests, and many of my guests are judges. But what inspired you to be a judge, Judge?
You know, I wish I could tell you it's what I wanted from the time I was a little girl. Actually, as a little girl, I wanted to be a nurse.
Oh.
When I went to law school, when I went to college, I had a professor who suggested law school. And but I took the LSAT anyway. I had a degree in English, and you know, what do you do with it? You can teach.
Sure.
And I ended up going to law school, and before I graduated, I became a police officer.
Oh, I didn't
Actually,
know
it was
that.
the other way around. I took the police test, so I was simultaneously accepted to the Akron Police Department and sworn into the bar. And at that point, despite the fact that I was very proud of having graduated from law school and thought a lot of the profession, it wasn't my heart yet. So I became an Akron police officer, just about 5 years, and went to the prosecutor's office. Never did the idea of becoming a judge ever enter my mind. And to be really honest with you, back then, and that would have been 1997, I was going to say 79, but that wouldn't be 97. It was just the right place, right time, right name, right background. And I started the Akron Municipal Court, and when I got there, I realized that those crazy turns I took, they were meant to be.
Well, I
was very blessed.
That's a real I didn't know that, Judge. So you were a practicing police officer for about 5 years?
Almost 5 years,
As a member of the Akron
Police
Department. Wow, we could probably have a show on that alone. My brother was a police officer.
Whereabouts?
In Richfield.
Okay.
And so that's where we all originate in Cleveland, but where our farm in Richfield is pretty much where most of my life was spent. Judge, I'm going to go into your past a little bit, and now that you've touched upon Akron
Sure.
Municipal Court, well, we probably should do one other thing. We don't want to embarrass you or anything, but you do have kind of an interesting spouse, so we should give him a little bit of, a little bit of airtime here.
Okay.
Your husband was a judge.
My husband was a judge. Yes, he was municipal and Akron Municipal and Summit County Common Pleas.
So the Callahans are quite the judge family here.
Quite the judge family. Our son,
Okay.
my son, whose birthday it is today, happy birthday, Michael, he wants to be a judge.
Well, good for him.
Yes.
He's got exactly the right bloodline. Okay. Well, I did, as I told you earlier, I had the pleasure of meeting your husband this morning in Medina Common Pleas Court and talked about your arrival here today. So, okay, let's go back to your Muni Court day. You were instrumental in the creation of the Akron Municipal Court's Family Violence Court. Tell us a little bit about that program.
Well, the great thing about the program is that it was such a collaborative effort because it was a diversion program. And when you start talking about having a domestic violence charge that you are going to dismiss at the end, people get a little touchy about it. So we made sure that police chiefs from all of the jurisdictions in Akron Municipal Court were at the table. Victim assistance was at the table. Battered Women's Shelter was at the table. The prosecutor's office, both city and county, were at the table. And the idea was if it's a true first-time offender, and if the victim approved, let's see if we could help get him to intervention, drug, alcohol, case management.
Sure.
They had a probation officer to get him employed. And Terry Heckman, who was and still is the Battered Women's Shelter head director, people would think she wouldn't be on board because of that dismissal at the end. But her philosophy was, so many of these are just getting reduced down to disorderly conducts without all of the counseling and the accountability. Yes, I'm okay. If you can have someone go through this one-year program, I'm good with it. And so that started in 1998.
You can say it.
And it went 10, it's still there, a different version of it, but I did it for 10 years.
Coming up on 20 years.
Yeah,
next
10
year.
years before I left, yes.
Well, I don't do too much in municipal court, not that my career is what we're talking about here today, but I recently did have a domestic violence there in that particular court, so I'm relating very well to what you're saying, and frankly, my client, I do believe, was a first-timer, and I think he felt very bad about it, and I think a program like that would be very helpful, maybe akin to, or at least an analogy to what you creatively came up with those years ago, was our treatment in lieu of conviction. Kind of a similar idea.
Absolutely, absolutely.
The dismissal, I always tell my clients it's the pot of gold at the end.
It is.
But I also tell them it's not an easy road to get there.
Nor should it be.
It should be, that's
Right.
exactly right. Okay, well, I commend you for probably the biggest challenge of the whole thing was trying to bring everybody together. I mean,
But everyone was very open, and everyone had their say and their input, and we modeled what I thought was a very good program, good enough to get a state award, and we actually got a national award.
well, congratulations.
Thank you.
Well, that's something you should be very proud of.
I am. We worked hard.
Okay, so I know we don't want to leave anything out, but Muni bench, how many years were you on it?
11.
Oh, you were on that bench for 11 years.
Yeah.
And then, like many of my guests, including your husband wasn't my guest, but he served as Muni court as well.
Right.
Judge Kimbler served as Muni court
Yes,
and
he
went
did.
to Common Pleas. That's where you got eventually, was Common
I
Pleas.
did, and I ran for Common Pleas, and I served there for 6 years.
Okay, so one term there.
Nope. I ran twice.
Oh, you ran twice.
I didn't do a second full term.
I see. Okay, well, that unto itself could be a show too, but during those years you were dealing with felonies.
Yes.
So I hate to say you're stepped up, but nonetheless, the penalties that go along with felonies are more severe than what we found in municipal court.
Truly, yes.
But legal issues of, search, seizure, and what you pretty well deal with nowadays can be found in both courts, obviously, if people want to
Absolutely.
appeal. So then you made the decision to become an appellant judge.
I did.
Well, I'm really interested now. I won't tell you about the little side conversation I had with your husband about this
Okay.
today. But why'd you do that? I mean, you were pretty successful about in everything you did up to this point.
I enjoyed common pleas, but I have been at this enough, and when I say this, I mean seeing how the judiciary works and how, frankly, politics works, to know that things don't always run on your time scale. Sometimes you have to go through the door when it opens up for you, and it just so happened to be that two of our very esteemed Ninth District judges, Judge Carla Moore and Judge Beth Whitmore, both chose to retire. And I couldn't count on there being an opening 2 years after that or 4 years after that. So I figured that was my time, and it was, hopefully I would be successful.
Well, we're glad you did. This is the Ninth District Court of Appeals. For the benefit of my viewers, this will take in Lorain County, Medina County, Summit County, and Wayne County.
Correct.
Okay, and you really do ride the circuit to the various.
We do.
Because I don't think I've ever seen you, but I probably will on your trip to Medina.
Absolutely.
But you sit in courtroom 2.
Yes, we do. Judge Joyce Kimbler is gracious enough to host us. Yes.
But that's the same routine in the other counties?
Yes, absolutely.
But you're home based in Summit County?
Our home base and our offices are in Summit County.
I see. Okay. Well, you get out and about, don't you?
I enjoy it.
Well, that would be kind of interesting. I mean, you get this, of course, you probably know a lot of lawyers from the two courts you worked at, but nonetheless, you get to see faces that you've seen before.
Well, it's true, and you see different faces because a lot of people, like maybe prefer to just do appellate work.
Sure. Sure. Yeah. Well, the next question that we have is tell me about what your typical day at work looks like, but we'll modify that a little bit here. Okay. The role that you play now, and this is the part that I really like to emphasize to my viewers, Judge, is, I mean, you now are litigants, defendants, plaintiffs, the state of Ohio and a defendant, whatever, have had their day in court, and they either won or lost. I mean,
Correct.
Before a jury, or maybe not even before a jury, depending on the court. But then there's always the issue that lawyers, by their nature, will say, well, yeah, but my client really didn't get a fair trial here. The search that the police officer conducted was inappropriate. It's a Fourth Amendment violation. Boy, you've got first hand on that, don't you?
I do.
You're the first judge that I've ever had in this show. Judge that was a police officer, so yeah, you get to see the whole picture, don't you?
I do.
Okay. Well, anyway, let's go back to my example.
Okay.
The lawyer is making this case and should have got a search warrant. You should. Okay, that's the Fourth Amendment of our Constitution. That's the type of stuff you deal with every day, right?
Absolutely. Absolutely.
So, all those years you sat on your bench and introduced, or the lawyers did, well, you did too, witness after witness, telling each side of the story, and then instructing juries as to the law. Exactly. And you would provide the law, they would analyze the facts, and I'm sure you...
And hopefully follow the law.
Yeah. Okay, so, and I'm sure you read your share of jury instruction.
I did.
But you don't do that anymore.
No, and I think something that people need to understand on the appellate level is it's not a retrial of the case. Sometimes we will have parties come to watch the appellate arguments, and I think they're expecting that it's a second day in court.
It's not.
It is, but not in the way they think. We're strictly looking at the legal and constitutional issues, so it's not the retrial.
Now, when I've seen your colleagues, and I'm sure you'll be there as well in Judge Kimbler's courtroom, there's 3 of you up there.
Correct.
Okay, so each of you at least the oral argument part of it, the lawyers are approaching you, both sides, and they have an appropriate amount of time to, well, I kind of hate to say make their case, but they are sort of making their case. They're bringing whatever issues that they feel was an error, and okay, but you got to listen to it. Your two colleagues do, but do we get a meeting of the minds here someplace?
Usually, often. Now, and keep in mind, they've already briefed the issues, so before we listen to them, we've had a chance to read their
Okay.
briefs and reply briefs, and
Sure.
so we've had a chance to maybe not look at the record yet, but look at the legal issues and even maybe a little advance on some research. And that's probably the biggest change from municipal and common pleas court, where I acted solo.
Sure,
And
sure.
now I act with two others at all times. And you know, the good news is you get to bounce
Oh, yeah,
ideas
yeah.
off someone else and glean from their wisdom and their experience. And but you know, if we don't agree, you certainly have the option of writing a dissenting opinion or even a concurring opinion. But that's
It's interesting.
not
but
all that often.
I, for lack of a better term, win and lose. That's not necessarily what this is all about, but prevail or not to prevail.
Okay.
But that lawyer who made his case said, you know, judges, the cop should have had a search warrant, you know, and everything following that was just the fruit of the poisonous tree. My guy should be getting a new trial. Well, let's just say, hypothetically, you agree. I mean, you briefed it, you know the law, you've conversed with your colleagues. Your position is, yeah, I agree with them, man. You know,
Okay.
the cops really shouldn't, you know, even being a former police officer yourself, you're saying that, well, whatever. Well, let's say your other two don't agree with you.
Okay.
How is this going to shake out?
Well, we'll discuss. They might show me, frankly, where I'm incorrect.
Okay.
We could discuss. I might show them, frankly, where they're incorrect. Or we just agree to disagree, as long as the two of them are saying, no, you know, we think the judge's trial court's decision was fine. And if I can't agree with that, I would write a separate opinion in dissent.
Okay. So the winner, so to speak, though, is the side.
The majority.
Yeah. So
Yes.
you're going to have to get two. I mean,
Exactly.
And there's no way you could break three into. There's going to be a majority, or that's what's going to be.
There's a per curiam decision, but that's a whole different road.
Let's say, in that hypothetical, that, you know, you went with, I really should have a search warrant. The guy really needs a new trial. Your colleague said, no, Judge, I don't agree with you.
Okay.
All right, so it gets written up, and that's the law of the land. I mean, you know, when it finally comes down, it comes down. Does the person who lost, so to speak, does he have an opportunity, or she have an opportunity, Judge, to appeal an appellate decision?
Well, the next step after the 9th District or any of the districts would be the Supreme Court of Ohio. The catch with that, though, is that they take a very small percentage of cases, so
They get to pick.
they pick. There are certain rules that they follow in picking their cases.
But what about you? What at your level? I mean, don't you get the opportunity?
No, anyone who appeals comes, you choose to file an appeal if it's proper, if it's timely, and if you're appealing a final appealable order, we will hear it.
So across the board, if you can,
Across the board.
if you, I think it's 30 days, you file your brief.
Correct.
And it could be a municipal case, it could be a common pleas case.
Absolutely. It could be anything from a small claims case to an aggravated murder case.
And if somebody can make the argument there's a constitutional violation or a statutory violation,
Or the judge erred and, you know, abused discretion, or, sure,
so here it comes.
we hear them.
You're going to hear them. Wow, your volume on cases is going to be considerably more than the Supreme Court of Ohio then.
Oh, well, it is.
Even though there are, how many districts, you're in District 9, do you know how many in the state of Ohio?
12?
Yeah, okay. And the geography sort of changes on the number of people. Like you take, what did we say, 4 counties?
I have 4 counties.
But I know over in Cuyahoga County, the 8th district is one number behind you. It pretty much just overlays over just Cuyahoga County because there's more people.
It does. That's correct. Cuyahoga is its own district. The 1st district down in Franklin is its own.
I see. Over in my other life, I think I told you I was a school teacher and
Yes.
a superintendent for the Findlay schools. That was in Hancock County. That was the 3rd District Court of Appeals. A lot of farm country out that
Lot of
way.
farm
That took
country.
in multiple
Yes.
counties.
Yes.
So that's how that works.
And as the 5th district, which is Stark County, but it goes way down, tips way down into southern Ohio.
Right. Okay. Well, that's kind of interesting. All right. So here we go. All right, let's go back to your
Okay.
typical day at work. You spend a lot of time reading.
I spent an incredible amount of time reading.
I take it you probably have a clerk or clerks that help you with this?
Not with the reading necessarily,
but I
but with, sure, to help with the writing. I have 2 judicial attorneys,
Okay.
and they help with the writing, and we bounce ideas back and forth and see if we come up with the same research, and
Okay.
I'm very blessed to have 2 very intelligent.
Great, great. Well, you may have picked up on this, Judge, in your long tenure as a lawyer and a police officer and a judge. But there's always a little grumbling on the outside by those folks like me who are defense attorneys that say, and maybe you've heard this before, why does it have to take so long? Have you ever heard that?
Oh, once or twice.
Okay, well,
yeah.
I
And
didn't
maybe
want- I
I've
didn't-
even said it once
I didn't
or
want to
twice.
spoil your day, Judge, but I
No,
mean,
no.
I just had to tell you. And so, I mean, I do have you a little bit on the hot seat here, but I mean, I'm not doing it
No,
deliberately, but
it's
it
not a
does.
problem.
There's a reason. You have about 30 days from when the trial court makes its decision. So let's say the trial court made its decision on May 1st. By June 1st, an attorney needs to file the appropriate appeal, with the 9th District, which here in Medina County, we actually have one clerk in our courthouse that does that.
Right.
Okay, so all the lawyers know where we need to go. And then it starts.
Maybe
Well-
it starts. You're assuming that the transcript
Well,
is
that's the
ready
whole
the
thing.
first
Here it
time.
goes.
Exactly.
I mean,
yes.
you could file your notice to say, I want to appeal, and I guess
Right.
you met your 30 days. But
Right.
if that transcript isn't available,
Then you have your extension,
But
maybe another extension.
but for the benefit of my viewers who don't know what a transcript is,
Okay.
that's what that stenographer typed or put into her machine every word that was said during
Sure.
that trial.
It's probably the most important part of the record.
So I've seen those, and you've seen even more than these, but those could go 1,000 pages.
Oh, thousands. Yes.
Because we actually had a stenographer on the show once. and
Oh,
it was
that's
kind of,
great.
interesting.
I'm sure.
Okay, so the stenographer gets that done, finally makes it available to the parties. So now it becomes brief writing time. I guess the appellant goes first. And
Correct.
now it's law school research. You have to dig out all those cases to make your argument.
Right.
File that, and then an appropriate number of days goes by. So, I mean, we started at June 1. We could easily be in October between the
easy.
transcript.
Easy.
Okay. And you guys haven't even heard anything much about this yet.
I don't
mean,
even know it's there yet.
yeah, right.
Correct.
Okay, but so the appellant puts his brief out. Maybe the state of Ohio comes back and says, well, we don't agree with you, and they write their brief. But at some point in time, there's something called oral arguments.
Yes, sir.
What is that?
All right. First of all, for the 9th District, if you don't waive it, you're going to get oral argument and expect it to be there. But
Okay.
oral argument is the attorney's opportunity to come in and, as I just said, not retry that case, but actually argue to a panel of 3 the issues. If they can't get to all of the issues in their brief, at least pick the ones
Okay.
that they feel are the strongest and the most important, and feel that maybe they can explain better speaking to us and addressing the court. The court may have questions, and each side gets 15 minutes.
That's it.
15. That's
You have 15 minutes.
right.
Okay, but anywhere along the line where I assume there's a podium and whoever starts out, the appellant is making his case to you, his or her. Can you interject? I mean, can you stop them and say, well, you're going to break his momentum if you do that?
I know. So it's, you know, yes, I can and I do. If there's a question I need them to
Well, okay, it makes
answer,
sense.
I sometimes, you know, us lawyers like to talk,
Well,
so
no doubt about
sometimes it's
that.
kind of tough to break in.
But the 15 minutes is still running on.
Yeah, and you know, speaking for myself, and I think I can for my colleagues, we're mindful of that,
Okay.
that we don't want to take up
Sure.
the time. And I've even seen the presiding judge, you know, stop the clock occasionally if we really have
Okay.
a lot of questions.
All right, but so here's the opportunity for the author of both of those briefs to appear before the three of you. Here, three lawyers are in front of you, and they're making their case.
Correct.
I'm sure you're listening to obviously every word that they said, plus, is there a transcript taken of that?
No, it's on YouTube. We do,
Okay.
people can watch the oral arguments on YouTube, but no, there's not a transcript.
But when you leave then, after, I mean, you do several of them, and then you head back to Akron from Medina or wherever you're
Okay.
at. Okay, but it's going to be a little while yet until we see a decision.
It will be. What we do after we hear is the oral arguments is we sit in conference. So we've already read the written arguments or the briefs, we've listened, and now three of us will sit together and we will conference.
I see.
You know, a lot of times you could feel one way, but that's not what the record shows.
I
So
see.
reading that record is very
Sure.
important. Now, does it take a while after that? Some cases take longer than others.
So the whole
Sure.
process could run about a year?
It could, depending on the case, sure.
Could be a year.
I used to joke at the trial court level, well, you know, for summary judgment motions. It's like, Judge, you know, do you need that much time before the trial date? And I'm like, well, no, you can have your choice. I can flip a coin, or I can diligently research and come up with the best response. Which one do you want? And, you know, I'd like to think we diligently research and come up with the best response we can.
I frankly, I mean, I suppose speaking as a lawyer, as I've grown in the profession too, I'm intrigued by this process. I mean, it really, not to take away from anything else, but the collaborative activity of looking at what does the law really say. And then, of course, once you decide, you give us a precedent, those of us in the
Sure.
field, that, you know, we can look to our own jurisdiction. Well, in the case of Smith versus Jones, Judge Callahan and her colleagues said, no, you don't need a search warrant. So,
And keep in mind, a decision that I write or one of my colleagues write may not necessarily be the outcome we like, but we took an oath to follow
that's
the
why
law.
we're this.
Exactly.
well, Judge, I see our time has gotten away from us. I want to thank you for being my guest on Law Talk today.
Thank you.
I've had a lot of fun.
I've enjoyed it.
Very much enjoyed it, and the invitation is open for you to return
Thank you.
anytime you want.
Thank you so much. I appreciate it.
Comments made by John's guest on Law Talk are solely those of his guest and do not necessarily reflect the views of Celebrezze Zangi Community Legal Education Project. To view this show and others, go to www.czclep.org. In the Wadsworth area, a complete listing of dates and times of this broadcast, tune in to WCTV Channel 15 or log on to wadsworthcity.com and follow the links to WCTV. At CZClep, we're devoted to the education of today's legal issues. Fueled by the public's keen interest in our legal system and current events, CZClep is dedicated to the educational venues aimed at enhancing the understanding by all citizens, regardless of age, education, occupation, or wealth. A function of the Celebrezze Zangi Community Legal Education Project.